Welcome, everyone, to the meeting of the International Intellectual Property Committee of the ABILA. I'm Sean Flynn. I'm the director of the program on information justice and intellectual property at the Washington College of Law at American University. And I'm co-chair of the International IP Committee with Peter Yu of Texas A&M, who's also with us today, and we will be co-chairing this session. So this year we meet as intellectual property and health has again risen to the top of the global trade agenda and occasionally even to the front pages of major newspapers. In October 2020, in the height of the COVID pandemic, India and South Africa proposed in the World Trade Organization a waiver of the WTO's provisions on the trade-related aspects of intellectual property rights agreement. We'll call that TRIPS here in this panel. The waiver of those provisions as needed to promote the prevention, treatment, and containment of COVID. One of the first major international policy announcements of the Biden administration was an endorsement of the core of that TRIPS waiver proposal, at least as applied to vaccine. The European Union, driven by Germany, where Moderna, the Moderna vaccine maker, is located, has opposed the waiver, but even the EU has come to the table with a proposal to make it very clear that compulsory licensing of patents on vaccines is permissible under the WTO agreements. So TRIPS is an agreement that requires all WTO members to have and enforce basic intellectual property laws, including patents on all kinds of products, such as vaccines. It also requires copyright on all expression and that trade secrets be free. And so the legal and policy debate has ensued and will be discussed today over whether the TRIPS waiver is the right approach to increase access to medicines and vaccines and treatment and containment measures. The US endorsement ensures that it will be a major topic when the WTO meets later in November this year at the annual ministerial. And it's expected that there'll be some resolution of this matter at that. So it couldn't be a better time to really discuss the genesis and some of the debates around the TRIPS waiver. We have with us today Professor Geneva Ositutu of the Florida International University School of Law, Professor Sri Raghavan at Texas A&M, Professor Sharon Sandeen of Mitchell Hamlin School of Law, Professor Josh Sarnoff of DePaul University, and we're also joined by special guest Fred Abbott of Florida University, Florida State University College of Law. And let me just check to see, we might be joined, I hope we're joined also by Anthony Taubman, who's from the WTO in the TRIPS division, but is probably very busy tonight. So let me turn to our panelists to discuss a little bit about what the TRIPS waiver is and how it might affect. Josh, can I turn to you and first ask you to describe a little bit about why you think the TRIPS waiver might be useful if you do?
Sure. So let me share my screen because I want to show one particular graphic. Can you all see it now?
Yeah.
And this is from today's New York Times data, which may be a few days old. But what you'll notice is that the high income countries, including the United States and much of Europe and Japan, are fairly highly represented in terms of at least one vaccine dose per person. And as you go down, with the exception of China and Brazil, scale of health of countries, you'll see that the wealthier countries are vaccinated at much greater rates. Some of the countries are still in the low single-digit percentages. And clearly something has gone in terms of our international distribution system. And, you know, the question is what to do about it. So the TRIPS waiver proposal was one effort of many to try to get at greater ability of countries to exercise their powers to be able to either encourage generic production or obtain access to the different vaccines. And it's not just vaccines, it's also therapeutics, and we'll soon see with Merck's molnupiravir, a significant therapeutic that's on the market that's not things like ivermectin and other things that probably shouldn't be promoted as treatments. But also, even at an early stage, there were masks, ventilators, all sorts of things that are not limited to high tech that would potentially be covered by the TRIPS waiver, and that would therefore be within the scope of COVID related technologies. So the basic question is why has this distribution, and I'll stop sharing my screen now, occurred? And it's not clear that things could not have happened without a TRIPS waiver. You know, Pfizer has been accused of patent infringement in using Neon Green patented technology to develop its data for regulatory approval. If they could go ahead and infringe, it's not clear why other countries can't go ahead and infringe, subject presumably only to reasonable royalties at the end of the day. But it hasn't happened. So presumably the most important aspect of the TRIPS waiver is that it is needed as a political matter to show worldwide solidarity that there are things that can be done and should be done. There's also the concern that with many inputs that are patented, it becomes administratively costly and infeasible to try to issue compulsory licenses for the wide range of inputs. But the most important piece of it, which I'm sure someone will talk about, probably Sharon, is trade secrecy knowledge, where we don't have a compulsory licensing regime, which doesn't mean that compulsory licensing is prohibited for trade secrets under the TRIPS agreement. And so the way I would put it is the waiver is neither necessary nor sufficient, but that doesn't mean it's not a good idea. That depends on your view of whether it would stimulate the proper political and risk-taking efforts by the relevant parties to change the distribution patterns that I've already mentioned. And I think I'll stop there.
So before I get into trade secrets, and I do want to go there, I'd like to stick on this kind of, the meta level for a minute about the dynamics and why we have this proposal. Jan, do you want to start off where Josh led off and maybe talk to us a little bit about the development dynamics and intellectual property and how this fits into that?
Sure, thanks, Sean. So I think that if you really can you hear me okay?
Yeah.
Okay. So I think if you step back and sort of take a big picture look at this, we have, since the time the TRIPS agreement was implemented over 20 years ago, this tension between sort of the developing world and the developed world, and the idea that that the TRIPS agreement and IP protections would ultimately be beneficial for everybody. And I think what we see now is sort of that this crisis has created an opportunity for countries to really stop and take stock and say, is this really working for everybody? And I think if you look at the proposed COVID waiver, it's actually, it's quite a shock to the system, because it's really after the TRIPS agreement and TRIPS Plus agreements and several years of building up IP protections, you have this waiver saying, WTO members should basically, for a period of time, not enforce pretty much all IP rights except for performers' rights and the trademarks, GIs, and plant varieties. So, I think that this is really an opportunity to ask questions about how IP affects development and human development, and really have that conversation. Because, in reality, because the WTO operates on consensus, I don't know if this waiver is going to actually go very far, but we're now having these difficult conversations. And so I would just say it's really, there are all kinds of debates. I'm sure other people will talk about this, whether IP really is the issue, whether there's it's about distribution and all these other questions. But the global pandemic is requiring us to rethink, I would say, our international IP standards, because we have these glaring disparities. And how much is it about the IP? I don't know, but in the middle of a crisis, a health crisis, after we've had the Doha Declaration on TRIPS and public health and everything else, in the middle of a health crisis, a global health crisis, over 100 countries are saying, wait, we want to roll back the intellectual property. So, to me, it's really an opportunity to, in light of the fact that we have the sustainable development goals and these international statements, these agreements that we're going to, try to lift people out of poverty and promote health and promote education, all these indicators of development, it gives us an opportunity to sort of take stock and say, 20 years later, how is intellectual property contributing to human development? How is it uplifting all? Right. And the last thing I'll say about this when it comes to development is just that if you look at the fact that the least developed countries have asked for extensions a couple of times and been granted extensions a couple of times. I think, as Peter says in his paper, when we talk about the waiver, we're really not even talking about the least developed countries, because they already aren't having to apply these standards. But, just that right there tells us that there is some question around development and how we're using IP, right? We see that with the rollout of COVID and with the IP producing countries the rollout of COVID vaccines, I should say, and the IP producing countries, we see this disparity. But, I think IP can be great. It can be a terrific thing for everybody, but it's obviously not working in the way that the rest of the world wants to see it work. So I think it's an opportunity for conversation at a very minimum. And as Josh said, whether it's good or not depends on your perspective. But, it really, I think, does illustrate the challenge when it comes to IP and development.
I think that's an excellent segue into some of your ideas. And do we need, one of the questions is, do we need a pandemic treaty, or is this really a signal of deeper problems, as Jan, I think, was kind of indicating in her message as well?
John, thank you. So a part of this is we had negotiated some flexibilities, right? So the Doha Declaration, Article 31Bs, all of these were negotiated flexibilities. And there's something that COVID showed. It is that most countries, at least the countries that seem to need the vaccine more, did not want to use it. And I believe part of the reason is because when they did use it during epidemics, forget the pandemic now, I think in a lot of ways, it was not a smooth transition to use the flexibilities. There were also sufficient national litigations barriers, the USTR, the EU Commissioner for Counterfeit Goods. So all of these together made the process highly cumbersome, right? Such that during the pandemic, most of these countries felt, look, we need an option to at least take care of the pandemic, right? And so that's how we are at a place where we have a waiver. And Josh was talking about some of the benefits and the positives and the benefits of the waiver. The two things that I think which sets this apart is something which Josh also said, which is that all IPs can be more easily included. Sharon will talk about it, trade secrets and copyrights and patents. But it's also a fact that the waiver has the objective of encouraging local production, something that TRIPS has always hesitated to do, and at least in the area of healthcare, right? Local production of some of these, some of these products is one way to kickstart innovation, right? I mean, if we see some of these countries that can locally produce become innovators, right, that would be the next stage of development. That'll actually work Article 7 and 8 of the TRIPS agreement better in some sense. But I do want to go into what you said, which is this: do we need a pandemic treaty? I look at the waiver as some sort of a loosely put together pandemic, not really a pandemic treaty, but a pandemic loosely put together effort. But what I believe we need is what Jan was really segueing into, which is that we need a public health treaty, right? So we can go back and tell the globe, look, if you have COVID now, we have the IP waiver, we have a perfect solution, right? But God forbid you have cancer, right? Then we got to wait 20 more years. It really doesn't help that way. So if anything, COVID's, it's kind of highlighting that there is a problem when it comes to the intersections of trade, IP, and healthcare, right? It's always existed in tension, right? Nobody can deny that, but this has exacerbated some of the tensions. And this also highlights to us that if the healthcare aspect of trade and IP is not really, if not reconciled, so to speak, then we are going to be at a point where the casualty is trade. So the whole idea of the World Trade Organization and the whole idea of all of this is to make productivity, so it's to help innovation, is to help productivity, and it's to make global trade more sort of robust. And we realize, and COVID has proved in more ways than one, right, that global trade will be the center, the most suffering. I mean, of course, human suffering is the highest, but global trade will inevitably, right, be a casualty if we don't take care of that, if we don't reconcile IP, healthcare, and trade. So to that extent, I think the waiver is merely the first step. And I certainly believe that we need a public health treaty that allows the trade organization, and I see, Anthony Tubman here. So I believe that what we need is the WTO to start working with more sort of the UN bodies, the WHO, and so on and so forth, to create a more sort of viable framework for healthcare, right? And we saw that yesterday with the Merck example, Merck's voluntary licensing of molnupiravir, I think that's how it's pronounced. So that I think is the first step, but what we need is a more sort of a good framework under which these things are worked. So thank you.
So that's, Sharon, I think that's a perfect segue into your issue. I mean, we have, Shri just mentioned one Merck drug today, a treatment that's been open licensed. Moderna also pledged its patents to the public. Why does IP even matter in vaccine markets if patents are being pledged, for public use? And you're a trade secret specialist. I think one of the things we hear a lot is around trade secrets. Do you want to explain a little bit about that background and how the TRIPS waiver, might or might not affect that part of the problem?
Yes, I want to talk about that micro issue, but first comment on the macro issues that were just raised, because I agree with the comments that were made. And the way I look at it, I consider myself a trade secrets and information law specialist. And the broader view of information is about information flows. And I think one of the things that's happening in international IP circles is there's been so much of a ratcheting up of IP protection generally that we forget that in order to have development, in order to have innovation and invention and creativity, we need to have knowledge and information. And so if we lock down information too much, if we prevent the distribution of foundational knowledge in particular, then we actually hamper development and innovation and invention. And this is why all IP laws historically have had what we call negative spaces. It's what is not protected is as important as what is. And what we're doing is we've lost that, and we're chipping away at it in a way that I think doesn't fully take account of the consequences on public health and on development. With respect to the micro issue of trade secret, with regard to the waiver, I actually think it's much ado about nothing. I don't think it will change much versus what countries can already do. And let me explain why. First of all, trade secrets are not like other intellectual property. They're not granted or registered. And also, importantly, they're not public. Now, I know of the other three types of IP, copyrights can be non-public. You can have unpublished works, but generally speaking, the patents, the copyrighted material, and trademarks are public. Trade secrets are not. And I should mention in the drafting history of the TRIPS agreement, although people still refer to trade secrets as intellectual property, it was a very important concession to understand trade secrets as a form of unfair competition, not as intellectual property, that led directly to the adoption of Article 39, 1 and 2. So we have to think about what does it mean to waive trade secret protection? Okay, the only way that happens is if there is a disclosure that makes the information generally known or readily ascertainable. And this is both good and bad from the perspective of the goals of the TRIPS waiver, which I understand to be to increase access to information regarding and access to medicine. It's good. It's a good thing because sharing of information under conditions of confidentiality is possible without waiving anything. And there's nothing in the TRIPS agreement that prohibits governments from requiring such sharing of information. Nothing except Article 39.3, which has to do with data exclusivity. But keep in mind the data in that case doesn't necessarily have to be a trade secret and often isn't. Okay, so what's bad about the special features of trade secret in this regard is that information owners can and they will assert trade secrets to refuse to disclose information to governments and others. And so we have a big problem in trade secrecy of over assertion of trade secret rights, coupled with insufficient and early mechanisms to test the sufficiency of such claims. And again, there's nothing in the TRIPS agreement that precludes WTO member countries from creating such mechanisms. Any country, including the United States, can create mechanisms to test the assertion of trade secrecy early. And my prediction is a lot of the claims will fall apart once they're interrogated. Now, that's less of an issue, though, I would acknowledge with respect to pharmaceuticals and the know-how in trade secrets that goes into making them that may not be and probably aren't disclosed, well, they aren't disclosed in the issues patents. So to me, the bigger issue with regard to trade secrets and other confidential information is how to compel or encourage information sharing of key information not disclosed in a patent, and whether or not it is protected by a trade secret. And so I characterize this as the problem of factual secrecy, not trade secrecy. There's nothing in the TRIPS agreement that prevents governments from addressing the problem of factual secrecy, but we haven't we haven't done anything with regard to that issue yet. Thank
John?
you.
Let me pick up on two things that Sharon said, which I think are important, and a little clarification in a second. The first is that we clearly agree that information sharing is needed for more rapid innovation. If you think what might have happened had the genome sequences of the SARS-CoV-2 virus been kept as proprietary data, it's true that other people could have accessed the the virus and tried to sequence it themselves, but there was a very rapid worldwide effort to share that information to start developing vaccines sooner. So that much is critical, that the concept of sharing of information is needed. And then the question is when is the restriction of information needed for innovation funding to develop things? And again, I'm sure people will disagree strongly about when that information has to be protected. But as Sharon said, it can be shared without losing the trade secret value. So that's the first thing. The second thing is in regards to TRIPS, Article 39.3 only protects against unfair commercial use. We clearly do not think it's an unfair commercial use for comparison to clinical data to show generic similarity. Whether it would also be a unfair commercial use for governments to compel that information to be shared prior to those regulatory studies is an interesting question, but nothing that's ever been tested. And again, to the extent that it diminishes value, there's nothing in TRIPS that prohibits governments from forcing companies to share their factually secret information. So I'm going to post to the chat a recent article by Amy Kabczynski that talks about the use of the Defense Production Act to force the transfer, not necessarily losing the trade secrecy, but simply force the transfer among competitors of information that otherwise might lead to limits on production capacity here in the context of vaccine manufacturing, which could then gear up the worldwide supply more rapidly in circumstances where the holders of that information are refusing, for whatever reasons, to voluntarily license it as broadly as people would like. There's an article that I won't post all the way back in May from Politico talking about how BioLice in Canada and SEPTA in Bangladesh, Teva in Israel, and Bavarian Nordic in Denmark all asked to assist in the manufacture of vaccines, and at that time had not been voluntarily licensed by the owners of the trade secret information. So it all comes back to, and this really is Jan's point, I think, if the system is not doing the things that we want, is it time to think about different ways of adjusting the system to do the things we want? And what are the downsides? And sadly, the economists can't tell us how things would turn out in a counterfactual world in regard to our innovation policy, and whether we would have the political will to tax more heavily and distribute money for innovation through government funding rather than through the private market of charging people for end use products. Those are critical issues that I think the pandemic is at least bringing to people's attention of, is it time to rethink how we fundamentally do our innovation system in healthcare? I'll stop there.
Hear that as a big theme in the group, that this is a canary in the coal mine. There's a much larger problem that we might need to address. I do have a question, Shri, that I'll come back to you in the chat of somebody wanting you to lay out your what is your global health treaty look like? But first, Fred, I'd love to bring you in. We didn't start off with Tony, so maybe I could ask you to address one of the points I think Tony was going to address, which is that question: is this really an IP waiver? What does it mean to waive TRIPS? You're muted right now.
Thank you, Sean. Yeah, so what we're talking about is taking action at the level of a multilateral organization to which governments have certain obligations. So the question that would really be raised by a government doing something that was inconsistent with the TRIPS agreement would be that another government or WTO member could bring a claim against them in the WTO dispute settlement body. Right now, the dispute settlement body is largely non-functional. We don't have an operating appellate body. In any case, WTO cases take 3 to 4 years to resolve. So the idea that someone might be under an imminent threat for doing something in violation of the TRIPS agreement as far as WTO law is concerned is a bit, let's call it speculative. But the second level issue there is that none of that affects what happens at the national level. So at the end of the day, whether a TRIPS waiver or is granted or not, except in a very few cases, would do nothing to affect what goes on within a particular country. So if there are patents granted in that country, if there are trade secrets protected in that country, if there is regulatory data protected in that country, none of that would go away, be waived or licensed because someone took a step at the WTO. So it's still up to each national government to do what needs to be done and over to, let us call it, overcome IP rights. In addition to which there are other international obligations, which others have pointed to, involving bilateral, regional, plurilateral agreements and so forth, which wouldn't be waived by a WTO waiver. So one has to be careful not to conflate a TRIPS waiver, which basically says you can't be sued at the WTO, with something happening at the national level, to which I would just add the further point that there may well be constitutional issues within a particular nation that would arise with respect to certain questions. You know, in the United States, you might have claims against taking of property without due compensation, depending on how the scenario played out. I'm not saying those would succeed. I'm only saying that this is a multi-layered problem from a legal standpoint, not a simple problem of let's get a WTO waiver because that's going to fix everything, because it would fix one thing, but it wouldn't fix a whole bunch of other things.
So Sean, let me follow up, because I think that Fred is absolutely right, but it fails to address the political dimension of what actions countries are willing to take and how the waiver might be interpreted in other international fora, such as ISDS, where a country takes action pursuant to an internationally recognized agreement consistent with that agreement versus in the absence of that agreement. And, you know, again, those are the things that may or may not be impediments under the current system to gearing up, independent production of the needed medical products. But that's why it can't be divorced. The law can't be divorced from the politics here. But whether the change to the law will change the politics is an interesting question that somebody at a much higher level would have to answer, because it's not clear why the politics haven't already changed given the outcomes of that chart and the other, worldwide effects that the current political configuration has demonstrated.
Peter, do you
To be
want
clear, Sean, I wasn't addressing the pros or cons of the waiver. You asked me to explain a technical issue, which I did, and so for what that's worth. Thanks.
Peter, do you want to jump in here and address, any of that discussion, what the possible effect of the waiver would be?
So let me pick up on what both Fred and Josh talked about earlier. So one thing I think would be quite useful for us to think about the waiver, to compare it with what happened with Article 31 bis. And I think there are a number of issues that are actually quite similar and that actually raise concerns for me in terms of the implementation of the waiver. I think the first one is what Fred mentioned early on about how it's not just about international, but it's also about domestic. I think Fred mentioned both the international obligations with respect to some of the free trade agreements as well as investment agreements. I think he also mentioned taking issue, for example, in the US. But one thing I think is important for us to not lose sight of the fact that for many proponents, there's strong domestic opposition within the country. So the position they're taking in Geneva can be quite different from what is taken in the capital, right? So in terms of domestic implementation, that can actually become quite complicated. And so for those of you who are students or who are into international law, this is what we usually refer to as a two-level game. You have the international game and the domestic game, and the waiver will only address the international game. And even within the international game, it's only part of it with respect to the WTO, and not with respect to FTAs, not with respect to other international agreements. And that's why the South Center, Carlos Correa and his colleagues just posted a new paper about how it's important for countries to actually ask for complementary waivers in other international agreements. The second thing I think is also quite similar, but that's also very disconcerting, is the timing it would take to actually get a waiver adopted. So if you go back to Article 31 bis, the protocol to amend TRIPS agreement was adopted, I believe, 2 weeks before the Hong Kong Ministerial in 2005. And the WTO did not get 2/3 of the membership ratifying the amendment until 2017. So it's basically a decade from the original proposal. And so there's an interesting question as to how they'll play out with respect to waiver. I think there's been a lot of discussion about how we need to try to push to get it adopted very quickly at the upcoming ministerial. At the same time, when you look at the past negotiation history, it actually will take much longer. And so it's unclear as to how that will play out. And we are going to go for a quick resolution where the developing countries need to give up a lot of different things. So one interesting scenario would be the EU will agree to continue to join the tax-based substantive tax-based discussion by focusing only on vaccines similar to the position taken by the USTR. Would the developing countries be willing to give up all the other requests in terms of health products and technologies and only focus on vaccine, right? So that type of question would be actually quite important with respect to negotiation, because they can get the resolution more quickly, but at the same time, is it better to have no deal or is it better to have a bad deal, right? That's always a very difficult question. The other thing which I haven't heard so far, and I hope you'll come up later on in discussion, is about the different side deals that are being explored at the WTO level. And I think it's very important for us to not forget that WTO is an international trade forum, and there has already been a lot of discussion about how the waiver negotiation have to be finished before the ministerial, because otherwise people will be using some of the other items or concessions as a bargaining chip in order to get a waiver. And I think for a lot of developing countries, they're actually quite concerned that, yes, if you have to get a waiver, you have to give up other things that you are likely to get in the ministerial, right? So I think there's been a lot of ongoing discussion about how the waiver discussion has to be finished before the ministerial.
Well, I think that's an interesting question that I would love to hear everybody's opinion on, is kind of what do you think is going to come out of this ministerial? Is there going to be a quick waiver and solve some other issues? That seemed to be where you were going, Peter. Do you think it's going to have a kind of quick resolution of this and then turn to other issues? Or do you think this is going to bog it down through the process?
I think the waiver will probably go beyond the ministerial. I think if
Won't conclude at the ministerial.
will not conclude at the ministerial, if countries can actually conclude at the ministerial, I think we will more likely to have a situation similar to Doha Declaration with different paragraphs, right? But not in the text similar to an amendment or waiver text that is closer to the August 30th decision that we got before we end up with Article 31 base. I think if we manage to get a waiver text, I'm actually unsure whether this is actually a good idea. If you look at the current waiver, I think it's a little bit too broad to say, well, about half of the provisions in TRIPS agreement will be waived because it's actually about half of the provisions that are relating to the prevention and treatment of COVID, right? That will be waived. And so it's much more purpose specific than what we have. But still, we are talking about close to half of the provisions. More than 30 provisions will be implicated, right? So I don't think that can be easily resolved at the ministerial. And if it can be resolved at the ministerial, the outcome is likely to be not in favor of developing countries.
And so, Shri, I think this is a nice time to turn back to you. You know, as somebody who started off this discussion saying we need a broader vision, what might you hope happens or doesn't happen? I mean, would you be advising for accepting a narrowed down limited deal, or is that the wrong step to take towards the broader vision that you have?
So I've always looked at the compulsory licensing and Doha Declaration as a narrower deal, right? It's narrower because it was focused on public health with certain flexibilities in the event certain things occur, right? And history has taught us that narrower deals did not work, right? It's also a fact that with healthcare and related issues, I think, international obligations are important, but it's important for national governments to take ownership. And the initial framework did not, in some ways, give that breadth for national governments to take ownership, right? During COVID, the best example I always give is how the US economy was decentralized to some extent. All of us got our COVID checks, right? I mean, and that's an example of how a national government takes on in a different aspect and decentralizes things, right? So at a WTO level, I believe the same things have to happen. And so for that to happen, something, it has to be broader. But that said, I don't think that within the ministerial, before the ministerial meeting, such a broad framework will ensue, right? I do believe that there may be some consensus for a more sort of narrower view, because the fear would be that it would set a big precedent of sorts, right? So I think the presidential effect of it will be daunting. I also look at this from a sort of game theory perspective. If you look at how this has happened over a period of time, big pharma tends to push back, right? And with COVID, I think big pharma has been cornered to some extent, but it doesn't mean that they won't push back. It doesn't mean that they don't have another act up their sleeve. So really, I mean, one waits to see how they would respond to this. And in some way, if their response continues to be imbalanced, I think this will take it to a new level of discussions, which again, I believe opens it up to questions of, do we need a broader framework that only discusses the reconciliation of public health and how those will be handled at a broader level?
So Jan, I would love to come back to you on that similar kind of question. I mean, of what you think might come out of the WTO what would be the potential positive effect of it if you think there would be one? Does it change the balance of power? Does it set up something that might have positive implications down the road? Does it shift something, or what are your views?
So I think this is a really interesting conversation. Like I said at the beginning, we're really coming back to issues that were raised early on, right? So we already have the Doha Declaration saying IP rights should not interfere with public health. Now we have this crisis and countries saying, let's get rid of half of TRIPS, or let's not enforce half of TRIPS, as I said at the beginning. And as Peter just said again now, which I think it's really a shock to the system. If you think about what we're talking about now, I think it is really a shock to the system. And so I do think that the conversations around IP and health are going to be different, because more people who weren't even talking about IP, who weren't even thinking about intellectual property, are now thinking about it in relation to health. So I think that right there changes the conversations that we're having. I also wanted to just make the point, coming back to the technicalities of what countries can and cannot do. I think it's really important to remember that the law and the politics at the international level are so closely tied. And so even if countries could do certain things domestically and not really have to worry about the WTO because it's in a bit of disarray, there's still the pressure that might be applied on them by the countries that are IP producing countries. So I think that's a factor that is relevant and still has to be considered. So to my mind, one of the important things we haven't really talked about a lot is capacity building and technology transfer. And, we do have in 66.2 of TRIPS that nations were supposed to, have measures to encourage technology transfer to developing countries. And so I think we could also ask 20 years later, 25 years later, 25 plus years later, what has really happened? So I'm not really optimistic that you're going to have any consensus about this waiver after the ministerial, but I do think that it's having important shifts in the conversation, and that we do need to have a broader conversation about what IP is doing in terms of the developing world. And lastly, I'll just say that the point that Shri raised about having a public health treaty or public health forum, I think that's a really important question, and something that maybe one needs to look at, because I don't think in all the discussions, we don't really have clarity, at least I don't really have clarity on how much this is really about intellectual property and how much it's about the other issues. And then, as some say, if you don't have the IP rights, they're not going to go ahead and create and innovate. So we do have, I don't think it's a straightforward conversation, but it would be ideal if we could see the developing countries have ways to incorporate the IP rights in a way that works for them, especially as like the African Union is thinking about their IP policy. How do you get IP policy that aligns with the Sustainable Development Goals, with the right to health? I think what this tells us right now is people are not seeing IP as supporting human health.
So Jen, let me push you a little bit on your position, because I think flexibilities are important. That's been frequently mentioned in a lot of the minutes of the TRIPS Council. But I think a lot of those proponents of the waiver proposal are tired of those discussions, right? Article 65 and 66 talks about how we need to provide technology transfer, and technology transfer is very important during the pandemic. And yet, the past 20 or so years have proven that those provisions are not working. Right. I think there's a question coming from the audience about the compulsory licensing arrangement. But even for Article 31, as well as 31 bis, is country by country, product by product, right holder by right holder, and limiting to patents. Right. So to the extent we need to use compulsory licensing arrangement to address the pandemic, it's also not that easy as well. Right. So if you were speaking from a standpoint of the proponent, what would you do, having a track record of more than 2 decades of not getting what you wanted based on flexibility?
So Peter, I think that you agree with me, but you just said it better maybe than what I said, because my point is that exactly all this time it's not been working. So I actually think it's going to it's a shift. It's time to shift the conversation. So I am not optimistic that the waiver is going to get through, but I think that at least we're having a conversation about intellectual property and developing countries and human rights that we were not having at this level before. So I agree completely with what you just said. It's 66-2, and we have already had the Doha Declaration. I mean, we've had this conversation, but I don't think that, in all honesty, that we're realistically going to have IP producing countries agree to throwing out half of TRIPS temporarily for COVID. I mean, I'm just being very realistic about it. But I think that at least we can start to really try to have more honest conversations about how the IP can be used in a way that's beneficial for everybody. Now, so I'll push. So I don't think you're disagreeing with me. And the last thing I'll say is that, you know, in many ways, the companies need to move, and governments can find ways to encourage their companies to move. So, you know, people say corporate social responsibility is a lot of talk and a lot of fluff, but a lot of companies now are also paying attention to this environmental, social governance, and, you know, really trying to show how they're complying with some of these metrics. And so I think there's room to think about that as well. The WTO is going to move too slowly. So, you know, one needs to pressure the companies to move a bit more quickly, and some of them are starting to.
So one technical point into kind of more world politics points. The technical point is that over the course of the last few decades that you've described, Peter, patent law doctrine has tended to reduce disclosure obligations, in particular in regard to the best mode of making and using, so that reading a patent disclosure is no longer sufficient for other parties to be able to make and use themselves what is being protected by the patent right. That puts much more pressure on trade secrecy, even without regard to the supplementary protection of post-filing learning that happens, particularly in terms of both clinical data and in terms of manufacturing processes, particularly for large-scale production. What that does politically is put much more pressure on the issue of trade secrets, which the world, you know, the TRIPS agreement really, as Sharon had said, and maybe she can pick up on this point, hasn't said very much about. And at least in terms of things like the manufacturing data, as opposed to the clinical data, manufacturing know-how as opposed to clinical data, is only protected against unfair commercial use. And the TRIPS agreement doesn't prevent governments from compelled sharing, whether still continue to be protected by trade secrets or not. So politically, there's going to be much more pressure in regard to trade secrets. The other political change which we're seeing is that developing countries, I believe, are no longer of the assumption that they can rely on trade markets to supply their needed biopharmaceuticals and other needed medical equipment for a pandemic. So you're starting to see lots more discussion of creating vaccine hubs all around the world, rather than relying on the more developed countries to supply, precisely because the distribution of that supply has been unequal.
If I could chime in here, I do not think it's any coincidence that at the same time, about the same time the American Invents Act was being adopted, there was launched an international effort to harmonize trade secret principles that led, for instance, to the adoption of the Defend Trade Secrets Act and the EU Trade Secret Directive. It was a sequential process. You know, let's amend the US Patent Act to make it more possible to hide information and knowledge and still get a patent. And then let's also ratchet up trade secret protection worldwide. Now, the good news is the trade secret harmonization is being done based on the Uniform Trade Secrets Act, which I have written about, is actually very limited, and it's limited for important public policy and historical reasons, which a lot of the world community outside of the United States doesn't understand. But one of the things that's missing from the harmonization efforts worldwide that countries can go ahead and start pursuing, because it's part of US law, is getting rid of all of the other theories of protection for information. So in the United States, it's very important to understand that there's Section 7 of the UTSA, which basically says there is no claim for any sort, no tort claim or equitable claim for any sort of information that doesn't rise to the level of trade secrets. This means that there's a lot of information that should be freely shared. The problem is that provision of US law has not been adopted internationally. And so you have countries that have other tort claims, the UK being one, that can protect a broader set of information than trade secrets. And this is what we need to address. And again, TRIPS does not prevent any country from doing that, from limiting and getting rid of all the other theories of protecting information, unless information meets the very specific, and I would say stringent requirements for trade secrecy.
Sean, may I intervene for a moment?
Please.
So just a couple quick points. First, I would suggest that we've been intensively debating the relationship between intellectual property rights and public health for over 30 years. So the idea that this is a new thing strikes me as a bit unusual. The main point I want to make is, though, that this whole conversation hasn't really touched on the priority of the interests of citizens and governments, by which I mean we seem to be assuming that somehow public health is subsidiary to intellectual property rights. I would just start with the premise that it's the sovereign inherent right and in fact obligation of every government to protect the health and life of its citizens, and that governments in the event of a pandemic outbreak have the right and responsibility to do whatever is necessary to protect the interests of public health of their citizens. And if that means overriding intellectual property rights, that is well within the powers of the government. Now, that may well entail political complications with another country, but no one needs to go ask permission, whether it's from the WTO or the WHO or from the United States or the European Union, to say that in the interests of my citizens, I am directing that my factories are going to produce X with Y technology. So I agree that this is a much broader set of issues. Tomorrow morning, I'm chairing another panel here on the reform of the WHO and the negotiations on the pandemic treaty and the broader issues. And there's been a tremendous amount going on about local production and production hubs and transfers of technology and private transactions and the MPP and so forth. And so this is by no means a unidimensional problem. The WTO is a small part of the equation, but I would just like individuals to recognize that governments are not constrained. They can protect the rights of their citizens. They don't need the permission of a politician in some other country to do that. I'll just end that brief commercial announcement there.
Yeah, let me also reiterate what Fred said in a different way. And that,
It's always appreciated, Josh.
hey, you know, I do what I can. And that is to say that,
Muddy it up a little bit.
you know, companies take risk. And the idea that they're likely to be subject to injunctive relief in this kind of a circumstance, when the standards for injunctive relief expressly allow consideration of the public interest, I think is extremely low. The only problem is that countries and companies can't take action when they lack the knowledge. And that's why it gets back in part to requiring the trade secret information be forced from the countries that have that information to those that don't, in order for countries to then take the risks or lack of, because as Fred correctly points out, the only real risks are a potential WTO dispute in regard to the waiver and an ISDS challenge, which is again just about money. It's not about stopping the action. So the problem is really a much broader one about how we control and incentivize knowledge production for worldwide benefit. And hopefully we'll hear a lot more from Fred and his panel tomorrow about how we do that better.
We'll finish it up short.
Thank you. So a couple of things I want to highlight. I do agree that governments have the right. They negotiated it even when they had it already, to reiterate that they had the rights, but it didn't really go well for them historically. I mean, repeatedly, we've seen countries being dragged for fair compulsory licensing that were instituted. So that's one thing I want to highlight. But I do want to echo what Sharon said with respect to how AIA tied in with trade secrets. I want to bring another thing that has been tied in too, which is the harmonization of regulatory exclusivities, right? So we've this is a time where AI technology is doing so well. So the amount of time it takes to collect the data, right, has decreased by manyfold. Jonathan Kimball and I wrote about it, and we looked at several things where AI has actually helped, and in some ways it's but there is still the effort to harmonize regulatory exclusivities, especially when it comes to biotherapeutics, etc., right? Biologics, biotherapeutics, etc., right? So that's one of the things I want to highlight. And then we, I think the earlier note was from Josh, where Josh talked about how different countries, I believe it was Josh, I'm not sure, different countries reacted differently. I wanted to refer to Ruth Okediji's paper here, right? Sometime back, she'd written a paper about how over a period of time, the TRIPS regime, even though we've continued to fight for public health and role of public health, right? Over a period of time, she highlights how the whole process when it comes to healthcare has yielded corrupt government officials, even in countries that that seems to have a diplomatic stance against the posture of IP, right? And she highlights how governments have slowly moved on to protect local industries and to talk about IP for their local industries. India is a great example. We were talking about it the other day as to how India has become a great example of, from a flag holder for, public health. In fact, India's historic policy, some of it I think would work very well during COVID. The price control aspect that India had, the time period for patent protection, and then of course the ability to compulsory license, all of the process patent regime, some of that will work now much better, but we see India moving towards trying to be a flag holder for, for strong IP protection, thanks to Bharat Biotech, right? So that's another thing I wanted to bring, and this was in response to an earlier argument that Sean had, not Sean, I think Josh made.
Everybody wants to argue with Josh today. Jan, do you want to jump in?
I'm not trying to argue with Josh today.
Want to pick a fight with Josh today?
You don't have to try.
I mean, no, I think that, I agree with a lot of the points that have been made. And I think that I would actually just really underscore what Fred said about this not being a new conversation. And, that's why I was trying to say, like, we've already had this conversation, and there was the Doha Declaration. And so I feel like this is really sort of, there's the crisis, the pandemic, and that has really brought this to the fore. My sense as well is that there's a fear that this is kind of an attempt to renegotiate TRIPS standards. And so that's probably some of the reluctance that that we're facing from some of the IP producing countries. But I do think that this is not a problem that's going to go away. And so the WTO is either going to address it, or maybe some other forum is going to, it's going to take place elsewhere, that there'll be more statements about health. And maybe this even actually wanted to hear more about Shree's proposed treaty, because I'm really curious as to how that would work in terms of WTO and other TRIPS plus agreements.
I think somebody asked about that, Shree. Do you want to respond? What's your public health treaty idea? Is it different than the pandemic treaty idea in the WHO?
Right. So I think I also sent a reply in the Q&A forum, but so the public health treaty is much broader, right, and not limited to just pandemics, right? And the idea is for two things to happen. One is for national governments to take stock of their, public health situation and have essential tools such as flexibility to address them. But of course, the other side of this is to not compromise, things like innovation and trade. So it's sort of a difficult effort. So then we move to what are the possible solutions. So we look at how this conversation has happened, which is what Fred was saying. This has been happening for 30 years now, right? There are several options that countries, academics, think tanks have put together, right, for a variety of mechanisms to deal with these, with all types of public health crises, right? For example, differential pricing at a national level or at a global level. Each country prices within itself. A country which has a very big class division like India, of course, can differentially price it nationally. And in some cases, countries can differentially price it for different countries, right? And then, of course, the idea of the type of technology that's given, so there can be local manufacturing, which would be the first step to kickstart some levels of local innovation, right? Harmonization is good, but we also look at including drugs that companies are willing to voluntarily license, like Merck's drug. Emory University alone has 5 patents over it. Right. The other day we were talking about Humira with 134 patents, right? And so in some ways to also tighten up the patent regime, right? Lycera had about, I believe, 164 patents. So in some ways to tighten up some of the loopholes that we see in the system. So that's another thing to do. The next, of course, I always think is for the WTO to work with WHO. And I've always said the first step is to ensure that amicus briefs from the UN, the WHO, from some of the, there has to be a system where some of these amicus briefs, especially on health issues, has to be given a more sort of persuasive value than what it does, what happens at the WTO level. But that again would depend on what Fred was saying. The appellate body is at this moment at least dysfunctional. So we need a functioning appellate body and of course a change in rules to consider some of these. So that's just some broad aspects, but I do believe that a new framework and a new treaty that does put healthcare right in the middle and not trade is required, right? Without, of course, compromising trade or innovation.
So since this is a National Law Association event, maybe one of you can answer the question of Vienna Convention interpretation. If two treaties are in conflict, the later in time controls, but what happens if the earlier in time has a non-derogation provision?
So we're talking about which two treaties here?
Any two treaties that are in conflict. The later in time would control, but the earlier in time has a non-derogation provision saying you can't adopt a treaty that's in derogation. Right.
So,
Well, how do you read those? What does the Vienna Convention say is the right answer there?
are you talking about the China's non-derogation from some of the trade
I'm
secrets
just asking
issues?
if your treaty was adopted and it conflicts with TRIPS, but it's later in time and the same parties adopt it, and assuming that TRIPS, which it doesn't, has a non-derogation provision, which controls?
Sure. So the idea is when it does get adopted, right? So we need to take care of the non-derogation provision and basically say that this treaty kicks in at this point in time and overrides TRIPS, right? I mean, that would be some of the things that needs to be put in, right?
Right.
So ending on that tongue twister.
It was really a forum negotiation question.
Oh, Henning might have an answer for us. Henning, you want to answer it?
Yeah, so Josh, if you
Let's
check
respond from
article,
Cambridge.
yeah, if you check article 30, subsection 2 of the VCLT, that basically tells you that if a treaty is specifying that it's subject to or not to be considered incompatible with an earlier or later treaty, the provisions of that treaty prevail. So if you have a non-derogation clause in a particular treaty, then the lex posterior principle is overridden. And by the way, that only applies to the extent that the treaties are on the same subject matter. So it wouldn't necessarily apply in between treaties, which, well, I mean, I don't know if there's any sort of ICJ case law on that. I don't know if Fred knows anything on that particular point, but the WTO appellate body has, in relation to Article 31.3c, which is somewhat similar, where it's about relevant rules of international law, said that they need to be in relation to the same subject matter. So you can't use a clause which has no real bearing on another clause's interpretation to sort of guide that. But you might, I mean, with the same argument, say that a non-derogation clause in a treaty not related to another treaty also has no bearing on the prevalence or not of that other treaty, if that makes sense.
Perfectly clear. Thank you, Henning.
So let me thank everyone for coming. We put the CLE information on the screen. I hope everybody got that. You need to sign the affirmation form, which is on the conference webpage in order to get CLE credit. And directly after this meeting, there's going to be a informal reception, and some of the speakers will be there. You can ask more questions there. And that's a reception of the International Intellectual Property Committee of the ABILA. And all of our speakers are members of the committee. And thank you, Henning, for visiting us. Henning's not a member of the committee because he's not an American, but we appreciate him coming by. He's also doing work on the question of what about all those other IP treaties that countries have signed? What does TRIPS mean for them? So maybe we'll pick up some of that at the reception. So thank you to all the speakers and to the audience. It's been great to see you. Thank you very much.